Good morning, everyone. It's our great honor and pleasure to welcome Justice Luiz Roberto Barroso, President of the Supreme Federal Court of Brazil, back to Princeton to deliver today's keynote of our timely Amazonian Leapfrogging 3.0 conference. We are all great admirers of the vitally important work that Minister Barroso does, and we are humbled by his efforts to fly overnight in from Brazil in the midst of an impossibly busy agenda. So thank you so much, Minister Barroso, for being with us. Minister Barroso recently visited Princeton and delivered a masterclass on democracy, populism, and institutional resistance, Supreme Courts in the game of power, examining the contemporary challenges facing constitutional democracy and the critical role of judicial institutions in safeguarding democratic norms in Brazil and around the world. First elected to the Supreme Court in 2013, Minister Barroso also serves as president of the National Council of Justice, the self-governing body of the Brazilian judiciary. While on the bench, President Barroso remains a professor of constitutional law at the State University of Rio de Janeiro. He holds law degrees from Yale Law School and from the State University of Rio de Janeiro. A consummate and daring intellectual, Barroso is the author of more than a dozen books and over 50 articles in Portuguese and in English. He has written pivotal opinions on climate change and on the regulation of artificial intelligence and the challenges it poses, and has a critically important commitment to addressing environmental protection and the rights of indigenous peoples. In his January keynote, Minister Barroso outlined the rise of authoritarian populism around the world and analyzed the common strategies such as direct communication through media, attacks on institutions, and efforts to weaken judicial independence. He emphasized that democracy today is based on votes, rights, and reason, and that courts play an essential role in arbitrating tensions between majority rule and constitutional limits. We were all intensely moved by Minister Barroso's call for civil society to mobilize and engage those in power to make what he said, moral resistance more powerful. History, as he said, is not linear. It is made up of advances and setbacks. Our role as citizens, as intellectuals, and as institutions is to push history in the right direction towards justice and inclusion for all. We cannot wait to hear from Minister Barroso on protecting the right to a healthy environment, such a key element on a possible and desirable Amazonian leapfrog, and to positively and meaningfully advance this vital Brazilian and planetary cause. So please join me in giving Minister Barroso our warmest gratitude and thank you.
Thank you, João. I'm very, very happy and honored to be here and share with you all some ideas, some thoughts on the right to a healthy environment, and specifically with thoughts concerning the Amazon. I just want to make a couple comments at the start. First of all, I'm not an environmental scientist or a climatologist or not even an activist in this area. I'm a judge. I'm a constitutional judge, but I'm a constitutional judge in a country where the Constitution addresses the issue of environmental protection very deeply. And we've had quite a few cases before the judiciary and specifically before the Supreme Court. And for this reason, I have become very interested in issues involving environment and specifically the Amazon. I have divided this presentation in three parts. In the first one, I'm going to address the issue of a justification of why courts are intervening in this matter. The second part, I'm going to talk a little bit about environmental protection in Brazil. And in the third part, I'll talk a little bit about the Amazon and specific issues that I think are related to the Amazon. However, at the outset, I want to make some introductory notes to state the facts over which I'm going to draw my conclusions and to organize my own thoughts and some basic things. And as I told João, I'm afraid that everyone here understands these issues better than I do, but I'm going to state these facts just to make sure that I have the right facts, so that you can correct me if it's the case. So one of the reasons why I'm interested in this matter is that I think environmental issues, and especially climate change, has become one of the most decisive issues of our time, and things are not getting better. And as I just heard Candido mention, hi, good to see you, earlier, the climate events witnessed in Brazil in 2024 should be a very clear alarm to what's going on. We had floods in Rio Grande do Sul, we had wildfires in Pantanal, we had a horrible drought, one of the worst droughts in the Amazon. So, and the wildfires in California that we could watch on television destroying entire neighborhoods. And from what I can notice, there are, I think, three challenges in tackling climate change and environmental protection. First is that we still see from the part of many governments, including in my country until recently, a total ignorance of the problem, a total denial of what's really happening, despite the fact that almost all scientists say we do have a problem relating to climate change. Second, politics is moved by short-term motivations, and quite often governments don't have the proper incentives to take the hard steps that must be taken. And the third difficulty we deal here, as has been mentioned earlier today, is that we need global solutions for these problems, because they are not located in just one country, and whatever is done in one place does affect the entire planet. As everyone here knows, we have several international treaties, conventions, and agreements trying to deal with this issue. We have the Framework Convention from 1994, we have the Kyoto Protocol from 1997, and we have the Paris Agreement from 2015. And according to the Paris Agreement, each country must voluntarily submit its nationally determined contribution. I was going to say a little bit about this, but it has been presented earlier, so I don't have to go over this once again. I want to mention that at the COP28 that I attended in 2023, it concluded the first global stocktake under the Paris Agreement, and the results weren't good. They concluded that the world is not on track to meet the 1.5 degrees Celsius warming limit outlined in the Paris Agreement. That was then. And worse than that, in 2024, for the first time, or it was the first year that the global temperatures exceeded 1.5 degrees Celsius above the pre-industrial era. So these are the main facts over which I'm drawing my next two chapters, and the reasons why we should be very concerned about what's going on. So the evolution of the role of courts is the second part of my talk. The involvement of courts in environmental protection and addressing climate change is justified for a few reasons, and I have selected three of them that I think are specifically proper to discuss here. First of all, the growing understanding that we are dealing with a human right issue. The growing understanding that a healthy environment constitutes an autonomous fundamental right, as has been decided by the Inter-American Court of Justice. So dealing and protecting fundamental rights is the typical role of courts. That's the first reason why courts got involved. The second I just mentioned, the lack of incentives for mainstream politics to deal with this issue. Because as I said, politicians usually are motivated by short-term goals, and we are dealing with effects that usually will be produced 25 years from now. The emissions that we're doing now, they don't produce effects immediately. And third, the judiciary has the role of protecting minorities or those who do not have vote or voice. And when we talk about environmental protection, we are not only talking about children that are not participants in the political process, but we are talking also about people that weren't born yet, and someone needs to protect them. So I think these are the three main reasons why the judiciary and courts more generally got involved in this matters. So in the first moment, when lawsuits relating to climate change or to environmental protection, when they were filed until a few years ago, courts would summarily dismiss them by invoking procedural issues or issues of standing. That was the typical grounds for dismissing those suits. And this still persists to a certain extent, but progressively, I would say, courts are starting to avoid the argument that this is a political issue, a political question, that the judiciary should not get involved. And there are a few important decisions that were taken in different parts of the world. One of the most famous was the Urgenda case decided in Holland. There's a more recent case, very interesting, important case. I was at the German Supreme Court, Constitutional Court, like a month and a half ago, and discussing this with their justices. A very important decision in the Neubauer case that you might have heard. For the first time, the issue of intergenerational justice was brought in a court of justice. And they decided that the climate law that they approved in the German parliament was unconstitutional because it was leaving too much burden for the next generation to face climate change. So there are a few decisions. There has been a reversal in an important case called Milieudefense. In the Urgenda case in Holland, the decision was that the government had to reduce its own emissions and it had to regulate third parties' emissions, private parties' emissions. Then there was a new decision, very interesting in a case called Milieudefense case, in which the Dutch court decided at the first level, at the lower level, that Shell, the oil company, had to reduce globally its emissions, which was celebrated as a very interesting and important decision. It was recently reversed, however, under reasonable grounds that you cannot impose that burden to one company in the market. And for that reason, the higher court reversed the decision. And as I mentioned, the Neubauer case was very interesting. And there is a trend, not in the mainstream yet, to recognize what they call rights of nature, to recognize rights to not only individuals, but also to rivers and forests and animals. As I said, this is not in the mainstream yet, but it's development that it's kind of building up, and I think over time we're going to reach that point. One thing that I should add in discussing the role of courts, and before moving on to how we deal with this in Brazil, is that the implementation of judicial decisions will always depend on the other branches of government. We need either legislation, and sometimes we can say there is a lack of legislation and Congress should act. We have done this in Brazil. Or we need the executive, because the judiciary, as a famous Federalist paper in the US says, we don't have the budget, the purse, and we don't have the force. We don't have the control and command agencies to make things happen. So we need the executive. And I'm telling this from my own experience. I was rapporteur before I was the Chief Justice in a case involving the protection of indigenous communities from invaders, from illegal mining. And we ordered the government to act, but we depended on the armed forces because it was in the Amazon. The Amazon has a very difficult logistic. You need the armed forces with helicopters and planes, and it was under a government that they didn't say we won't comply, but at the last minute they said we have a problem. We don't have money for this operation you have ordered, but so we need to postpone it. So they never said we're not doing it. And in one case, if you could believe, it was a secret operation so that people wouldn't be warned that we would remove them. And the head of the federal police published it in the official gazette. So just to let you know that when a government doesn't want to do it, they find many ways to avoid the implementation of the decisions. And so I now move to our next part, which is environmental protection in Brazil. The Brazilian Supreme Court plays a role that is a bit different than the role played by courts in other parts of the world, which gives the court a bit more protagonism than courts have usually in other countries. And that's for good and for bad. But the reasons are, first, we have a very comprehensive constitution. The Brazilian constitution deals with many issues that in other parts of the world are left for politics. So the Brazilian constitution, as any democratic constitution, deals with separation of powers. It has a Bill of Rights, and it organizes the state. Brazil is a federal state. But besides that, the Brazilian constitution also addresses the social security system, the healthcare system, the educational system, the environmental protection system, the protection of indigenous communities. It regulates mining. It regulates the political parties. It regulates the role that the state, the government should play in economic affairs. It protects the family. It deals with the media, you name it. So the Brazilian Supreme Court decides cases that in other countries they would never decide. They would just say, this is a political question, this is a political matter. But in Brazil, these issues become legal issues. For example, Article 225 of the Brazilian Constitution says, everyone has a fundamental right to an ecologically balanced environment, and it's the duty of both the government and the community to defend and preserve it for present and future generations. So here we have, it's a fundamental right, it's a duty of the state, of the government to protect, and it has to take into account future generations. And then the same article has several paragraphs describing the attitude, the behavior, the action that the government must take to protect the environment. So environmental protection in Brazil is not a political issue for sure. And that's the reason why the judiciary has interfered in many instances with the policy adopted in environmental matters, especially because until a couple of years ago in the previous government, we did see a type of view of the problem that was in total denial. We had a major increase in deforestation in the Amazon, and we had the dismantling of the main agencies that were involved with environmental protection and protection of indigenous communities. And for that reason, the Supreme Court interfered in at least three important cases that I'll mention briefly, although the consequences of our interference have been mentioned here before. The first one was involving the National Climate Change Fund, the Fundo Clima, which was established precisely to fund projects to mitigate climate change. And the government had totally suspended this funding of this project, and the money was there. It was a rubber stamp money. It couldn't be used for anything else. It was a very strange kind of behavior regarding environment and climate change, because even though the money was there, they didn't present any plan. They didn't fund things. And I just heard that BNDES is funding several projects of reforestation, which is very important, I think. So first thing the court did, I think, was a pioneer, was to establish that environmental treaties are a subset of human rights. So we did acknowledge that this is a human right question, fighting climate change. And second, the decision said environmental protection and the fight against climate change are not political choices, but constitutional, supralegal, and legal obligations of the federal government. Supralegal means when you acknowledge that a treaty is a human right treaty, that means it's above domestic law. It's below the Constitution, but it prevails over domestic law. And second, we said that the government could not withhold the funds allocated to the Fundo Clima. So we ordered the government to release these funds and present projects. This would be very uncommon for a constitutional court in other parts of the world, but that it's perfectly acceptable. And they did comply with this decision, not funding what we would think the best projects, but then it would be too much for us to interfere into that. But they did comply with the decision. The second decision, close to that, was the Amazon Fund. That was even worse, because that was money that was coming from Norway and Germany, as you probably know, in the REDD+ framework. And they simply froze the money. The money was there, but they weren't using it. And then they changed the bodies of governance of the fund, and Norway and Germany decided they wouldn't, they suspended the funding of these projects, and the court ordered the government to reestablish the governance that previously existed so that the money would keep flowing as it was before. And once again, what we decided was the decrees that revoked the Amazon Fund's governance committees was unconstitutional, and we ordered the government to reactivate the fund. Very atypical decisions for the Supreme Court in other parts of the world. And the third decision that we rendered was in a case during the previous government asking for us to declare that there was a unconstitutional state of affairs in the policies regarding the Amazon, which in fact was the case. And we started the judgment by saying that. But it was stayed before the end. It was resumed after the new government. And the new government, as you know, had resumed the action plan for the prevention and control of deforestation in the Amazon. So we didn't declare a unconstitutional state of affairs, but we did order some complementations to the plan, and we ordered the restructuring of the two agencies that had been dismantled. FUNAI, that's the Indigenous Communities Protection Agency, and the IBAMA. Couldn't translate that. So these were three cases decided by the Supreme Court. But I must say that in lower courts, there are dozens, maybe hundreds of cases in which environmental matters are decided. And under my presidency, we established every year the main goals of the judiciary, main goals, usually 12 goals, and one of them is giving priority to deciding environmental cases in lower courts. And finally, one word about the Amazon. Of course, I won't reinforce here the importance of the Amazon. Everyone knows here for its biodiversity, for its role in the water cycle and the rainfall regime, its role in carbon storage. But in what regards law more generally, we have many environmental crimes that are not being fought properly in the Amazon. Basic ones are first, crimes defined in the penal code, in the criminal code as crimes. First of all is deforestation. And as you all probably know, the primary cause of deforestation in the Amazon rainforest is the establishment of pastures for cattle ranching. So deforestation is the first crime. The second one, it's forest fires. Quite often to suppress vegetation that you want to get rid of, they set fire, clearing areas, again, for cattle ranching and sometimes for agriculture. A third major problem and crime is illegal logging and timber trade. A significant proportion of timber produced in Brazil is totally illegal. Over 50% is illegal. The statistics vary from 40 to 80%, but certainly a great amount is illegal. Illegal mining is also a major problem. When you talk about illegal mining, the main impact is not it's not deforestation exactly. It's the contamination of rivers with mercury. That's very lethal for indigenous communities, as you certainly know. And that raises one issue, Beto, that it's in my mind, and we're discussing this at the court, the issue of mining in the Amazon and in indigenous communities, which is kind of a taboo. No one wants this. However, this is what's going on that is striking us at the court. In order to mining in indigenous lands to be acceptable, the Constitution requires proper legislation and the consent of the indigenous communities. Legislation has never come, so they never produced this legislation. But in some indigenous communities that you visit, when you get there, you only see children and women. And then you ask why. And all the men are working for illegal miners. So there is a growing process of illegal mining in indigenous communities with the participation of the indigenous, or at least part. This is very divisive in indigenous communities. But we are now facing this difficulty. If you don't regulate it properly in some way, you kind of foster illegal mining with the complicity of many of the communities. So I'm not issuing any opinion here. I'm just bringing up a problem that is real, and we need to address it at a certain point. And I even would like to talk to you, Beto, about this a little bit, if we have the chance. And we have, land grabbing, and we have murders of forest defenders that are not punished properly. We have corruption of public officials to turn blind eye to crimes or to regularize illegally occupied properties. That's another problem that we now have. And on top of this, and I'm coming to an end here, there is a problem that has been growing increasingly in recent times. The Amazon region has become relevant in international drug trafficking. It's a route for drugs, with the municipalities located along the water and road routes used by traffickers. So, and I've said that before, the military especially had a great concern about preserving the sovereignty of the Amazon, because they always thought the foreign powers were interested in the Amazon. But the risk we are running right now is losing sovereignty of the Amazon for organized crime. And that's very, very serious. And I think we should have this on top of our agenda also. Finally, I'm a little bit scared of saying this last chapter, but in a debate I had to participate, and people asked some paths toward the preserving of the forest. And at the time, that was for the COP28, for the debate, I prepared a list after reading a lot of people, many of them are here. And I have 9 items, and I'll close. Some paths. 1, command and control actions. There is the clear necessity of repression, and the time that we were able to really lower deforestation was because of strong command and control actions. There is potential for an expressive increase in the production and export of forest products. 3, adding industrial value to forest products. 4, restoration of degraded areas. I do have a chapter on that if we want to talk, but I do understand that this has become an important governmental project, as the BNDES representative was explaining. Investment in low-carbon agribusiness without increasing deforestation. Legal industrial mining supported by proper impact assessment. Legal timber extraction with responsible forest management. Green tourism, and payment for environmental services. And I want to end this presentation and start the debate with Racia, and you're going to profit much more from her than from me, is the following. In the present context, Brazil, unfortunately, but it's true, cannot become a global or industrial or technological leader. That's our circumstance at this moment. I think we should invest in technology, and we need to recover the participation of the industry in our GDP. But right now, we won't be technological or industrial leaders in the world. But we have all the conditions to become an environmental leader in the world. That's our role at this moment, because we have mostly clean energy, 3 times the global average. We have renewable resources. We have wind, we have sun, we have biomass. We have many important projects involving sugarcane. As I'm sure we all know, we are advancing in the energy transition. There is this major political issue involving the margem equatorial, which is the acceptance or not of exploitation of oil close to the Amazon. And above all, we have the Amazon that renders all these services to humanity that we have the duty to protect. So this is a role that I think we should actually become the global leader in what regards environmental protection and fighting climate change. Thank you very much for your time.